recent decision out of the Toronto Bankruptcy Court deals with the concept that when a company or person files for bankruptcy, a consumer proposal, or even a notice of intention to make a Division 1 proposal, that there is an automatic stay of proceedings. What that means is that anyone attempting to begin or continue any action for the collection of a debt is stopped and cannot continue that action without leave of the court. But in this case, it also arose out of the fact that the Toronto Sheriff's Office didn't properly understand what the stay of proceedings means when it comes to evicting a residential tenant who has filed for bankruptcy. So in this Brandon's blog below, Brandon describes the court case, the associate judge's decision, and what a stay of proceedings in a insolvency proceeding actually is and is not. My name is Ira Smith, president of Ira Smith Trustee and Receiver, Inc. Both Brandon Smith and myself are available to answer any questions you may have, either about this Brandon's blog or anything else at all. So shoot us a message, give us a phone call. We would love to speak with you. I hope you enjoy the rest of this video and find the information useful.
Hi, I'm Fiona Ledger with licensed insolvency trustee firm Ira Smith Trustee and Receiver Inc., serving the Greater Toronto Area. Today I want to clear up a dangerous misconception that could cost you your home. Many people think filing for bankruptcy automatically stops eviction. That's not always true, and I'll explain why. Picture this: you're drowning in debt, behind on rent, and facing eviction. Someone tells you, just file for bankruptcy, it'll stop everything with a stay of proceedings. So you file, thinking you're safe. Then the sheriff shows up anyway. This happened to a tenant in Ontario just this year. Despite filing for bankruptcy, she was still evicted. The case is called Rees-Nath, and it reveals critical gaps in how people understand bankruptcy protection. First, let's understand what a stay of proceedings actually does. When you file for bankruptcy, or a consumer proposal, or even a notice of intention to make a proposal, Canadian law creates an automatic legal shield. This stay immediately stops most creditors from starting lawsuits against you, garnishing your wages, seizing your property, making collection calls. Think of it as hitting the pause button on debt collection. But here's the crucial part: it doesn't pause everything. The stay of proceedings has important exceptions. It doesn't stop criminal proceedings, family support payments, and crucially, eviction enforcement when your tenancy was already terminated. In the Snaith case, the tenant owed over $46,000 in rent. The landlord and tenant board had already ordered her eviction before she filed for bankruptcy. The court ruled that since the tenancy was terminated first, the bankruptcy stay couldn't stop the sheriff from enforcing the eviction order. Here are the critical takeaways. Number 1, timing matters. Filing before eviction proceedings gives you better protection than filing after. Number 2, you must keep paying current rent during bankruptcy. Post-bankruptcy rent isn't discharged and can still get you evicted. Number 3, pre-bankruptcy rent arrears become unsecured debt, but the damage to your tenancy may already be done. So what should you do if you're facing both debt problems and potential eviction? Act early. Don't wait until you're already in eviction proceedings. A consumer proposal might be better than bankruptcy for keeping your home, as it allows you to pay a portion of your debts over up to 5 years while keeping your assets. Most importantly, contact Ira or Brandon Smith to get professional advice. Every situation is unique, and the interplay between bankruptcy law and other rights is complex. If you or your company is struggling with debt concerns, don't gamble with your family's security. Contact our office for a free consultation. As licensed insolvency trustees, we'll explain exactly how bankruptcy or consumer proposal protections apply to your specific situation. Call us at 905-738-4167 and check out our website at irasmithinc.com. Remember, understanding your rights before you need them is the best protection of all.